if you happen to attend a for-profit college or university, you are likely to face, on any transactions with that for-profit college and university, an arbitration clause, mandatory arbitration clause. However, if you go to the University of South Carolina or Connecticut or Georgetown, no such thing exists. So as a business, they impose these arbitration clause, forced arbitration hearings. We've got clear example after example of these schools that have gone bankrupt. And once they've gone bankrupt, their students claim that they were defrauded. In many cases, they were. So far, we paid out $535 million in student debt relief for students who were defrauded by for-profit schools who had no recourse in court. They had an arbitration clause, which meant the average student wasn't going to challenge the school. The taxpayers lost in that exchange, and these students, many of them still hanging in suspense, don't know what they're going to end up doing in terms of their future because of being defrauded by a for-profit college and university. I have a bill I put in that eliminates these arbitration clauses. If you're going to take in college student loans to facilitate the education of these students, you shouldn't be imposing mandatory arbitration clause on. Mr. Bland, have you run into that?
Yeah, we've represented a number of people who went to a for-profit school that promised them, we will place you at 98% in your industry. And it turns out, so if you went in and you were a busboy in a restaurant and you came out and you still had a job as a busboy in a restaurant, but you'd paid $30,000 to the for-profit school, they considered that a placement rate. Or a lot of times they just lie about the placement rates. There's all kinds of deception in that industry, and there are people who go in, and they're middle-class people or sometimes lower-income people who are trying to better themselves, trying to improve their lives. They take out these huge loans, and if they come out and they get nothing, and they've just been completely lied to and screwed over, and then once they discover that and they try and bring a case and there's an arbitration clause that just blocks them and pushes everything into this secret thing where class actions are banned, there's nothing you can do. I've had a bunch of clients whose lives are basically ruined by these. Your bill is a great thing. I'm really grateful for it.
Well, thank you. The point I'm trying to make is there are many grievances and there's a lot of unfairness and discrimination in employment and other activities. I certainly heartily endorse the idea of exempting discrimination cases based on gender, race, and so forth from mandatory arbitration. But the point I believe Professor Gillis met, there are many other aspects of justice that need to be served. Forced arbitration does not serve them.